Okay, hey everybody. Sorry about last night. I ended up really very sick from heat on Wednesday night, and Thursday I basically was not able to do just about anything. Normally, when I have to miss a class, I'll post a video like this that night, but I was having trouble with word selection and other fun things like that, so I figured I'd wait till this morning, Friday morning, when it would actually make a little bit of sense. So we're going to review the things sort of in brief that we would have reviewed last night, and we can discuss any outstanding questions you guys have this coming Thursday. So I posted some stuff about false confessions. I hope you find that interesting. It's a really interesting psychological phenomena and police phenomena, and it's something that a lot of people think went away when it became clearly illegal to torture confessions out of people, but it does still happen, and it still happens fairly regularly. So we're going to touch on confessions fairly briefly, because I think those videos do a good job of going over the major issues with those. But this chapter, Chapter 5, talks about interrogation, confession, and Miranda, and we're all, to an extent, familiar with Miranda rights, which are the rights that get read to a person upon their arrest. That said, you'd be surprised probably how many arrests happen without Miranda rights being read. If police don't question somebody, and they don't intend to question somebody, they don't actually have to read them their rights, because those rights pertain to the rights you have when being questioned, and when being questioned while you're under arrest. If police question you as a witness or for some other reason and you're not under arrest, those Miranda rights do not apply. Now, prior to Miranda, the whole thing with interrogations and what your rights were very confusing. And it's not that you didn't have those rights, you just didn't have any guarantee of being informed of those rights. So you had those rights to the extent that you knew you had them and knew how to effectively exercise them. I still, when I talk to people teaching, about the criminal justice system, when I'm working with younger groups, I tell them that it's very important, if you get arrested, to say, I will not submit to questioning without an attorney present, and I am invoking my right to remain silent. Because then, on the record, you've stated that these are my rights, and I am going to invoke those rights: the right to remain silent, the right to have an attorney. Now, initially the police did not want there to be a rule for this before Miranda and during the process of the Supreme Court case that became the Miranda decisions, because the Miranda doesn't give a lot of latitude to police officers. The only latitude police have is that as long as the substance of the rights is conveyed, they don't have to follow one particular formula. You can tell a person about their rights in any order. Usually the right to remain silent is told first, but if you want to tell them about the right to attorney first, that's okay too. And that's about the only thing police officers get to choose in the whole matter. So the Miranda rights specifically, you have the right to remain silent. You have to notify them that anything you say can and will be used against you in a court of law. You have the right to talk to a lawyer and have the lawyer present with you when you're being questioned. If you can't afford a lawyer, one will be appointed to represent you before any questioning. Note that that does not say at no cost. Some states will say at no cost, but in many states it's not a guarantee that there's no cost. Public defenders are not always free. In fact, in a lot of states they aren't. I think we talked about that a little bit a few weeks ago. The next one is you can decide at any time to exercise these rights and to not answer any questions. You can also decide not to make any statements. And then finally, do you understand these rights? And that last bit there sometimes is darn near impossible to get a clear answer to, because you want somebody to say yes or no. because then you know, and have on record, and these days have on body cam in most cases, the person acknowledging that they understood those rights. There are some exceptions. Voluntary statements. If somebody just blurts out something and they haven't been Mirandized yet, that can be used at trial. This actually happens fairly regularly, especially with suspects that are under the influence. They will just say stuff as you're arresting them or before you arrest them. All of those things can be used in court. Routine questioning. Name, age, date of birth, address, things that are not considered to be incriminating. So basic, demographic data about an individual. Emergency situations. Where did you put the gun? Where is the child? Where is the missing person? Those are emergency situations, and there is an emergency exception to Miranda. And then routine traffic stops, because the person is not normally placed under arrest, do not require a Miranda warning. That said, Miranda warnings will apply if that traffic stop then leads to an arrest. Now, when somebody has an absolute right to remain silent, that means that they can choose to exercise that at any point during questioning. So if you have somebody that started talking to the police and then decides to stop, they have the right to stop. They have the right to invoke their right to remain silent. And they also have the right to invoke the right to an attorney at any point, and at that point, questioning has to stop. The role of a paralegal here is generally in reviewing police questioning and looking for issues. There are a lot of arrests where police do not Mirandize people when they should, or they don't Mirandize them soon enough. They start questioning before they Mirandize them. So it's something that as if you're working in a defense capacity that you need to be aware of. Now, one thing that is interesting that police are allowed to do that a lot of people don't realize is that the police are allowed to use trickery and deceit, as long as they're not using trickery or deceit to try and get around constitutional rights. So they can lie to the suspect. We already have evidence against you. We already know what happened. Your brother has already told us that you did X, Y, and Z. They can do that. That's something that is allowable for the police. The penalty for violating Miranda is really straightforward. Anything that comes from that questioning cannot be used in court. So if there's a confession, and that's all you now have nothing. Now, you will not generally be in the capacity of doing any questioning that would be covered by Miranda, but again, if you're in a defense capacity, it's important to keep an eye on anything that could be used to exclude incriminating evidence against your client. Interrogation is kind of art and kind of science. And I mean, anybody really who's followed the whole question of, torture of detainees and whether or not that gives you good evidence and that sort of thing is aware to an extent that there are a variety of ways with different levels of reliability to question people. I have a good friend who was a translator and interrogator in Iraq during the early stages of the war there, and he said that the best way he's found to interrogate somebody is to bring them tea and food and ask them what he can do for them. And that it is largely art. Some people kind of have it, and some people kind of don't. Now, I'm going to leave to you things to read about psychological profiling and things like that, because that's not something you'll be actively doing as a paralegal, and it is generally acceptable in most cases for police to engage in psychological profiling, as long as they don't violate any of the individual's rights in doing so. Now, again, we come back to the issue of when an arrest happens. We talked about this when we talked about arrests, but it's also important as far as Miranda rights go, because these rights arise when somebody is not free to leave. Custody, in the case of invoking your rights, simply means you're not allowed to leave. That doesn't have to be jail. It doesn't even have to be the police department. It doesn't have to be in a police car. It can be anywhere where where if you get up and leave, the police can't chase you down and stop you. Now, that also applies to this idea of picking up somebody for questioning. Unless the police actually have probable cause to pick up that person and hold them, then they cannot do that. Any confession from that would be thrown out. Now, if they have probable cause, they can do so, and it'll generally be pursuant to an arrest. And regular Miranda rights will apply. So, like I said, I'm going to kind of breeze over confessions because I think those videos hit a lot of the major points. One thing to keep in mind is that police can make some very limited promises to defendants, but they can't promise them, the world. They can't say that, a certain outcome will result, that a certain sentence will result, because that's not something police have any control over. They can say that, I'll ask for a reduced bond, or I'll tell the judge you cooperated, and maybe you'll get, less bail, because that's something where a police officer's opinion might be taken into consideration. But if promises besides that are made, then chances are pretty good that any confession that arises as a result of those promises is going to be thrown out. So, we are going to move on now to Chapter 6, which is arraignment and discovery. And now when we start getting into discovery, we're really starting to talk about areas where the paralegal is going to be very, very active. But first we have the arraignment. And this happens when you have a grand jury indictment in a felony case. So you have a true bill of indictment that's been returned by a jury, and then an arraignment is scheduled. At this point, the defendant is told what the charges are and given the opportunity to plead guilty or not guilty. If the defendant has an attorney, which in most cases, once they're indicted, they're probably going to get one, then that attorney will make that response, although the defendant will appear in court still. If the person cannot afford an attorney, then at the arraignment, they will usually request that the judge appoint an attorney for them. So they're called appointed attorneys, but they work the same way as a public defender would for other non-felony indictment type cases. Procedure at arraignment. You can find videos of this online. It's very straightforward. There's usually going to be a whole list of arraignments going on. Most of them take 5-10 minutes, really, at most. There's a case file number. That'll be announced. The defendant appears, starts calling the defendants for each case. They have to respond when their name's called. And if somebody fails to appear, usually a warrant will be issued for their arrest. This is called a bench warrant. Usually when a defendant is called, they stand up, identify themselves, and then announces either that they intend to plead guilty or not guilty. If a defendant says they want to plead guilty, then they'll actually be asked to stay, and at the end of the day, depending on the situation, they may be sentenced right then. If they plead not guilty, they'll be given a new court date for their jury trial. If there's an attorney present for the defendant, the attorney will do all the talking, and the defendant will do none, generally, unless they wish to plead guilty, in which case they'll be asked to respond to some questions from the prosecutor to ensure they understand what the outcome is of pleading guilty. So plea bargaining. Most criminal cases in the U.S. Do not go to trial. They're either a guilty plea or a plea bargain, which results in a guilty plea. So usually what happens here is that the prosecutor will recommend a lesser sentence in exchange for defendant's plea of guilty plea. And this can be done by either recommending just a lesser sentence or by reducing the charges, either dropping the number of counts of something or, a first-degree murder charge could be reduced to a second-degree murder charge, which would usually in most states give the person the option of parole. They might still get a life sentence, but instead of life without parole, it would be 40 years to life with the opportunity of parole after 40 years, or something along those lines. Why plea bargain? There are good reasons from both the prosecution and the defense side. And both of them boil largely down to time and money. Jury trials are expensive. They take a lot of time, they take a lot of money, and in many cases they're still going to result in a verdict of guilty. So from the defense standpoint, especially if you're looking at a public defender, they have a massive caseload and probably don't really have the time to take a lot of cases to court. So if they think the person is almost certainly going to be found guilty, then they're probably going to encourage their client to consider accepting a plea bargain. Sometimes it's also because the state doesn't have much of a case. Now, one thing that's important to keep in mind is that the decision to accept a plea bargain is at 100% up to the defendant. The attorney can advise on this, but the attorney cannot accept a plea bargain on behalf of the defendant, even if they think the defendant is being ridiculously stupid by not accepting it. That's something that comes up in defense cases is you may, as working for the defense, know good and well that person's guilty, that they're going to be found guilty. But if that person decides that they want to take it to trial, that's their decision to make. Now, for a guilty plea, a few things have to happen. First of all, the defendant has to voluntarily and knowingly surrender their rights. That's the right to an appeal, the right to a jury trial, and so on. And by intelligently or knowingly, it means that not only are they not being coerced into this, they actually show an understanding of the situation they're getting themselves into. Now, a plea agreement can sometimes be a really great deal. Often is a really good deal for a defendant, but it can also be kind of not as good of a deal because a plea bargain is a deal with the prosecution. It's not a deal with the judge. And a judge does not necessarily have to abide by the recommendations in a plea bargain. They often will. In fact, most of the time they will. But if they think that the sentence should be much more than what the prosecution has bargained for, the judge has the right to do that. They can also decide it should be less than the prosecution and the defense have agreed to ask for, in which case it would be beneficial to the defendant. But usually, if it's going to go one way or the other, it's going to go the other way, and the sentence is going to be longer. There are other types of pleas besides guilty and not guilty. I think I briefly mentioned the Alford pleas that we see in Virginia. Not all states have those. Your book talks about nolo contendere pleas, which are similar, which basically is just saying I'm not going to argue this case. Everything else remains the same, so it's functionally a plea of guilty. But usually what happens is that there's a civil case going on too, and pleading guilty means admitting guilt, which will then be used in the civil case to prove that the person was in fact guilty. And usually it requires the judge's permission to plead no contest or nolo contendere. These days, states are moving away from the Latin and just calling them no contest. Then there's the Alford plea. In the Alford plea, the defendant maintains themselves as innocent, but they functionally are pleading guilty and are sentenced as if they had pled guilty. If the government's case, the prosecution's case, is really strong, and the possible defenses are pretty weak, then, okay, maybe they can plead guilty while maintaining their innocence. The name comes from North Carolina v. Alford, where the Supreme Court says, well, actually, yeah, a defendant can choose to plead guilty while protesting their innocence. This is, because generally when somebody pleads guilty, they have to specifically say that they are guilty, that they did commit the offense for which they are being charged. And since some people plead guilty for strictly economic reasons, because they can't afford to take it to trial, they can't afford bond, they're going to just end up sitting, in prison for 3 or 4 months while they're waiting for their case to go to trial. An Alford plea can be a desirable alternative where they can maintain their innocence. So moving on to discovery. Discovery is a process of the exchange of information. And this can be fairly extensive, but it's often a one-way street. In criminal cases, civil cases are very different in how they handle discovery. It's much more extensive. There's a lot more back and forth and exchange of information. Now, the way this works is the prosecutor often starts the trial without really knowing what the defense is going to say. But the defense starts the trial knowing basically, in most cases, what the prosecution is going to say. The prosecution is required to provide, even without being asked, any evidence that might tend to indicate that the defendant is not guilty of what they have been charged for, or that they are potentially guilty of only a lesser charge. Now, the defense attorney will also know the names of witnesses and whatever crime lab and forensic reports, but while the defense attorney would know the name of the state's witnesses, they're not going to know what those witnesses are going to say. They're not usually going to have statements from them. Deposition is one way of gathering information. So deposing a witness is when you ask a witness questions under oath in front of a court reporter prior to the trial occurring. The deposition is then transcribed and the transcript can be reviewed. They're very frequently used in civil cases. They're not often used in criminal cases, at least traditionally. And that's because a criminal defendant has the constitutional right to confront a witness. So usually what happens is that a deposition at a criminal trial usually has to still have the person who gave the deposition available to be questioned. They have to appear, take the stand, and testify. So sometimes, why would you do this? Well, in some cases you may have a witness become unavailable. There were cases where somebody was slated to testify and then was killed or mysteriously disappeared. A deposition is a way around that if your defendant or if your witness becomes suddenly unavailable. Not all states yet allow this, but more and more are. So it'll probably be something that I think is on the increase. We actually, American National has in the past actually let attorneys rent rooms at the Roanoke Valley campus to hold depositions because we have so many courts in our little regional area that sometimes it can actually be hard to find neutral places to hold depositions. So it's always important to keep an eye on what the discovery laws for criminal cases are in your state. This is one thing that does tend to vary a bit in state courts. And with technology and sort of changing ways that we gather and compile evidence, it's getting more complicated, and so discovery laws are fairly actively changing. So make sure that you keep abreast of this. This is something that, once you're in practice, keep an eye out for continuing education on this, because it is something that's going to change. Now, certain types of information cannot be discovered in the discovery process. Work product. We've talked about this when we talked a little bit about privilege before. Work product by either the prosecutor or the defense attorney is not discoverable. The criminal records of witnesses in many states, although not all of them, you cannot get the criminal records of the witnesses. That said, if you can find them yourselves, you have them. But it can be hard to search all 50 states to make sure, that the other side's witness is not, for instance, a convicted violent felon or something. In some states, prosecutors have what's called an open file policy. This still isn't hugely common, but it's starting to be recognized as a best practice, where basically a defense attorney can review the entire state's file on the case and copy anything they think is helpful. None of this is mandated by law, and the fact that one district attorney uses it can't be used to force another one. But it does circumvent claims that they're withholding evidence in discovery. So, I would think personally, and I'm not a prosecutor, but I would think personally that this would be a good way to defeat appeals and wrongful convictions. So, Brady material. Brady material is a certain class of discovery that has to be disclosed by the prosecution to the defense. And these are the materials that are favorable to the defendant's case. This was a Supreme Court decision that said when the state has evidence or information that tends to show that the defendant is not guilty of the crime, the state has to produce that. And the reason for this, of course, is because a prosecutor's role is not just to get a conviction, it is to seek justice. It is to convict the correct individual of the correct crime. Now, we do still run into situations where prosecutors have hidden Brady information, and it has resulted in wrongful convictions. And it's unfortunate that still tends to be the case. Well, I don't want to say tends to be the case. Can be the case in certain instances. It's usually politically motivated. Somebody's about to, run for, state attorney general again or something like that, and so they have, a certain degree of political pressure to alter certain types of material they provide to get convictions in high-profile cases. So, briefly, pretrial motions. The defense can raise a lot of motions before trial. We're just going to hit on a couple of them. Motions to suppress. This is asking the judge to rule certain evidence to be inadmissible. This is done a lot. A lot of defense attorneys feel there's nothing to lose by doing this. Now, this would usually be situations where evidence was seized in violation of a defendant's constitutional rights. But sometimes, even if there is nothing really obvious, a defense attorney may still file these because, again, there's really nothing to lose. Motions in limine. This literally means, and your book translates this incorrectly, it literally means a motion at the threshold. Doesn't mean at the beginning. It is, because the idea is that it's at the threshold of the trial. And this is where the defense attorney is asking the court to suppress certain pieces of evidence or limit certain types of testimony, usually relating to what a witness is going to say. For instance, the example your book gives is a very typical one. If a defense attorney thinks that a particular witness of the prosecution's is going to refer to the defendant's criminal history during their testimony, and that's not something that's allowed, because that's character evidence. So if there's reason to believe that, then usually the request will be granted, because the defense can't risk that being brought up, and it would give grounds for an appeal, so the judge doesn't really want that to happen either. There are a few others, just briefly. A motion to reverse a deal. If somebody has been offered a deal to testify, then they can, that information can be requested by the defense attorney, and they can request that the deal be revealed to, the general court. And since it is common practice to offer some type of a deal to, especially co-conspirators in a case, revealing the presence of that deal can be very informative to a jury. Motions to sever. In other words, this is asking the court to try different counts separately, or to try different defendants separately. Motions for change of venue. This is just asking that it be moved because the jury pool is believed to be tainted. So when motions are filed, the motions have to be argued prior to trial happening, and usually there will be a day put on the calendar called a motions day, where you argue all of your motions. And usually there will be arguments, there may be briefs requested by the court, and the winning party will usually be asked to draft an order, saying that, for the judge to sign, saying, okay, this is what we agreed to in court. That's something a paralegal will often be asked to draft. And they're usually pretty boilerplate. You're probably going to have a form for them in most offices for common motions, where you will literally just fill in the blanks with the information. Okay, so that's all we're going to talk about for right now. We'll be doing chapters 7 and 8 next week. I don't believe we have a quiz next week, and I will see you all then. Have a happy Memorial Day weekend, or I should say a good Memorial Day weekend. Not really a happy holiday, but otherwise, I will see you guys next week.